Ms Legalista here. Welcome to another video. Back to talk about Aussie media and the media mogul wire fraud case with Carlos Watson and Aussie media. For those of you who've been following along, there has been some stuff going on in the background. And I want to talk about the documents, the paperwork, the rules that you sometimes see play out in court as, this one saying, hey, I don't think you can do that under the rules. And this one's saying yes. And then they got to go to the judge. And the judge is like, well, submit this. I want to hear your thoughts on it. And then I'll make a decision. And then we'll have an order. Well, in the background of this case, there has been this sort of back and forth between counsel regarding these exhibits. And I want to share with you this letter that the government sent about the defense exhibits, them not meeting the timeline. Some of the exhibits are irrelevant, there are duplicates in there. And there are a couple of things that come to mind when I read this letter. My first thought is, do we want to piss off the government and make them mad at us when they're already, taking us to court? Number two, I start to wonder about the balance of power here. You have the government, the US government on one side of the table, and then you have a company, its founder, and the attorneys on the other side. It does not look like to me there's a balance there in terms of access to being able to pull together documents, to meet timelines, to follow the rules. We think of rules as being very much something that's not an issue. Like, it applies to you, it applies to me, and there's not going to be anything that affects me differently or you differently. Like, the same rule is going to apply to both of us. For instance, if I'm driving, I see a stop sign, hey, I have to stop. That's the rule. You're driving, you see the stop sign, you have to stop. That's the rule. So we think these things play out the same for everyone. But think about it. If you're going to court against the US government, you have the full weight of the US government coming after you. Most people don't have the resources that match the federal government. Let's just be clear about this. So I'm going to go into this letter, and you'll see a lot of things that the government's saying, you did this wrong, you did this wrong, under the rules, you did this wrong. We believe that's wrong too. Can't believe you didn't do this. The judge told you to do this and you still didn't do it. But the government, isn't it in a easier position to be able to follow the rules? Whereas your regular Joe or Jane walking into court is like, okay, I got to hire somebody who's then got to do it. I got to pay for that. Do I have the money? Does the firm have the capacity to pull this off? Oh, I don't know. I'm going to pull up the letter. You tell me what your thoughts are in terms of what our legal system looks like. And when we say, yes, you have the right to counsel, you have the right to have your fair day in court, you have a right to be heard, you have a right to be judged by your peers, but is that enough? And what does all of that really mean when you have to show up in court and you have to defend yourself against charges like these? Well, let me not hold back anymore. Let me just pull it up so you can see it. And I don't know why I'm so brown. I don't know. This is like funeral Ms. Legalista or something. I'm using my new laptop, my Snowball that I had for years, but I hadn't been using it. I've been using something else, and my hair keeps getting caught on everything back here. But I look weird. This color is just off. I don't know. Maybe I look like this in real life, and I'm the only one who doesn't know that I look like an alien. But here we have this letter, and this is only a few days old. And this is why I talk about this, because this is currently relevant. This is this conversation that's going on in the background. And here's the key concept to keep in mind. If the judge were to say, you were late, you didn't mark the documents like I told you to, I'm going to say you can't put any of those in. I'm not going to allow you to have any of those in the trial. Well, I'm wondering, is there anything in there that would have been really relevant to the case that would have impacted a jury's decision making and the overall outcome? So do you get to really decide on the merits if you're keeping things out because somebody didn't meet a timeline. But again, it's a rule. You know what the rule is. We're gonna take a look at this. I just think a lot of this is a lot more complicated. You don't hear those kinds of issues being talked about because it's going on behind the scenes, behind the curtain. And I probably talked too much about this. So let me just look at it and we can talk about it together and see what it actually says here. So May 27th, 2024, the Honorable, this is our U.S. District Judge, Eric Committee out of the Eastern District of New York, United States versus Carlos Watson and Ozzy Media, Inc. Dear Judge Committee, now remember, this is from the government side. This is from the prosecution going after Ozzy Media and Carlos Watson. The government respectfully submits this letter in response to defendant's May 26, 2024 exhibit disclosure. I'm going to come back to that. I actually should have showed you that first, where they're asking for more time. I'm going to do that in a separate one. While the court has already issued an order denying the defendant's request for leave to file these exhibits late, the court further noted that it will consider appropriate remedies in the coming days. In other words, the judge also is concerned about making sure that this case is decided on the merits. For the reasons stated below, the government respectfully submits that the proper remedy is to preclude the defendants from admitting any exhibits not previously disclosed by or to the government, and any exhibits not identified as a potential defense exhibit in the defendant's prior May 22nd, 2024 exhibit list. On May 24th, 2024, the court ordered the defense to produce to the government no later than 5 p.m. on May 26th the 250 exhibits it currently believes it is most likely to introduce in its case in chief. The court further ordered that these exhibits be individually pre-marked in accordance with the court's individual rules. The court cautioned that the defense should not assume that exhibits it does so produce will be admitted over a timeliness objection. So they're still going to allow the government to say, hey, that's not timely anyway. Don't admit that. That will depend on, among other things, whether, when, and how the item was produced in discovery and what prejudice, if any, the government would suffer from the late introduction. Based on the terms of the court's order, most of the defense exhibits should be precluded. As a threshold matter, the defense exhibits do not comport with the court's individual rules. The court could not have been clearer with the defense that its exhibits must be individually marked. And you can see they have stated there what the judge had said. Of the 250 exhibits that the government received after 9 p.m. on May 26, after the court's deadline, remember it's at 5, as noted in the court's May 27, 2024 order, 0 were individually pre-marked. Although this may not be grounds for preclusion standing alone, it falls into a larger history of non-compliance by the defendants with the court's orders, continues to burden and inconvenience the government, and should factor into the preclusion analysis. So let me stop here, because this is where I get to this point where I start to wonder myself about who has option to what resources. And this color, I'm telling you, this color is killing me. Every time I look at myself, I'm like, that is not the color I am. That is so weird. So 0 were individually pre-marked. My question would be, why were they not pre-marked? What was going on behind the scenes? Help me understand so that we can make a better informed decision about, well, hey, did you just, I don't know, because it was in the order. So I don't know, share that with us. Then the government then says a larger history of non-compliance by the defendants. Again, what is going on with the non-compliance here? And I'm going to go to that letter to help you understand some things that happened that may have impacted some of this. Sometimes things are outside of your control. All right, so let's go down to this next paragraph here. Next, the vast majority of documents on this list, approximately 185 of the 250 exhibits identified, have not previously been produced by or to the government. So we got a whole bunch of new stuff. This is alarming. The government wants you to think. The government first requested disclosure of the defendant's Rule 16 materials more than a year ago in a discovery letter dated April 21st, 2023, and renewed its request in letters accompanying every subsequent discovery production. More importantly, these 185 undisclosed documents should have been produced in response to the grand jury subpoenas issued to both defendants and pursuant to the court's July 28, 2023 order to compel. Producing these 185 documents to the government after jury selection late at night on the Sunday before trial is set to begin approximately 10 months after the order to compel takes sandbagging and flouting the court's orders to the extreme. Now, if you have watched some of my latest videos, you know I talk about how attorneys will get to writing and you think they are writing some fiction out there because they know how to throw this stuff together. But this is how you lay it out. If you want to make a case for saying they are the bad guys, they aren't following the orders, we've given them opportunities time and time again. Look at how long it's taken. Here it is a year later, and they're just giving us some of this stuff, and then they didn't even do it right. So that's basically what the government is saying. And it just is a really bad look for the defense. And again, it makes you wonder what's going on behind the scenes that's causing these kinds of delays and, quote, non-compliance. What's their response to this? What does the defense have to say? It says, at a minimum, these 185 documents should be precluded on this basis. In addition, the latest defense exhibit list illustrates the gamesmanship at play. So now they're trying to say, hey, defense is trying to play dirty over here. And let me tell you why. Of the 250 exhibits, 218 of them, the 185 referenced above, plus an additional 33, were not on the approximately 3,100 item exhibit list provided to the government on May 22nd, 2024. This moving of the goalposts is part of a larger pattern with the defense, and it leaves the government in a position of scrambling on the eve of trial, which is exactly what Rule 16, relevant precedent, and this court's individual rules are designed to avoid. So that's a whole lot there. That's a whole lot there. Again, I don't know how many times to say it, but it does make you wonder what's going on behind the scenes here. It really does. It says the prejudice from the late disclosure of these exhibits is further heightened by the significant authenticity concerns around the defense exhibits. The defense exhibit list included a created date/time column, and 117 of the 250 total exhibits were created between May 24th through May 26, 2024. All 117 of these recently created documents, which purport to be contracts, insertion orders, and other agreements that Ozzie had with third parties over the period 2016 to 2022, fall within the 180 documents never before produced to the government. They're saying we haven't seen these before. The defense has not explained, one, why these documents were never produced before, two, why metadata associated with the documents identifies them as having been created within the past 3 days when they purport to be agreements from 2016 through 2022. So yes, they went back and looked at the metadata. This one is not, it could be that they were recreated, that the documents were out there before, but they've been resaved or recreated under a different title or document name. And so, yes, now they have a new created date, but it could be that the documents were old. So this number 2, I'm not sure I'm buying it. I think I would have to hear more about that. Number 3, why the documents were not included in either of the defendant's prior exhibit lists, notwithstanding the defendant's claim that their May 16, 2024 exhibit list of over 6,300 items consisted of the entire universe of documents that could be offered by the defendants at trial. That's a lot of documents. The authenticity concerns are especially acute here because the government anticipates that it will prove at trial, among other things, that the defendants conspired to falsify and forge business agreements on numerous occasions, including by changing dollar figures and modifying other key terms to make them appear more favorable to the company. At this late stage of the case, the government has no realistic means of confirming that the agreements the defendants have identified in this latest disclosure are accurate and authentic. And that may be a point that that may be a legitimate point. Excuse me. Finally, even the defendant's narrowed list of exhibits continues to include documents that are plainly irrelevant and inadmissible. Well, okay, so the inadmissible piece is one thing. If it's inadmissible, well, okay, irrelevant, how do you know? How do you know what they're going to use that document to argue? And inadmissible, I don't know. A lot of times there are exceptions. Things are generally not admissible, but in some cases, they may be admissible under some sort of exception. So how do you know it's not meeting? Like, it's interesting to jump out as the government and sort of say, your stuff, you can't admit that and you can't admit that. Well, it sometimes depends on the purpose of why you are admitting this. And I'm going to bring this up when we talk about this person who resigned. This is just a lot. For example, within the 65 defense exhibits that had previously been produced by the government under Rule 16, there are multiple duplicates, including one email that appears to be included on the defense list 4 times. Okay, it's kind of like, when you got the list, can we go back and double check? Again, I feel like this is a resource issue. Like, maybe they don't have enough people working on the defense team. Maybe they don't have enough time committed to it. Like, I really feel like some of this is a resource issue, and that this, needs to be addressed, and it may be too late. I don't know. And a junk document that has only a third-party logo from a signature block. So again, somebody who's going through your documents at the very end, like, this doesn't even have to be another attorney. This could be a legal assistant or a paralegal whose main purpose is to make sure that everything's labeled, that everything, is the proper document that we say it is, that it's not a junk document. Within the 185 unproduced documents, approximately 15 of them appear to be contracts or insertion orders from 2016, well before the charged conspiracy. Okay, yeah, but you don't know if that is going to be used to talk about something that came up later. Like, I'm not buying some of this so easily from the government side. Some of this, it depends on what it's being used for. So you're like saying, yeah, you can't talk about that because it's from way, it might be relevant to something though, right? An additional 5 appear to be contracts or insertion orders from 2022 and 2023 after the charged conspiracy. Again, my same thought here. Well, I don't know yet though. And one of the documents appears to be an exact copy of the Excel spreadsheet that was used to support the proposed expert testimony of Barry Pincus and David T. Robinson on the topic of revenue, which was created after the fact and is replete with multiple levels of hearsay. Thus, even among the set of documents that the defendants are, quote, most likely to introduce in its case in chief, unquote, a substantial portion of them, based only on a cursory view. Okay, thank you for giving us a heads up that all you did was a cursory review. You didn't actually go through and see how something might be related to something later and how it might be used, appear plainly irrelevant and inadmissible. The court here issued a simple order. The defendants violated it yet again, and they did so in a manner that prejudices the government. At a minimum, to limit that prejudice and to prevent the defense from gaining an unfair advantage from their misconduct, the court should preclude the defendants from admitting any of the 218 exhibits not previously disclosed to the government or not identified as a potential defense exhibit on defendants' prior May 22nd, 2024 exhibit list. And here's the thing. When they don't do this, when the government says you can't have that, that's going to be one of the first things that we list on the appeal. If they lose, if Ozy Media and Carlos Watson loses, they're going to be like, hey, these exhibits should have been allowed for these purposes. It did not overly put the government in a bad place or prejudice them or inconvenience them to this extent that they make out. Like, yeah, that's what they're going to do. And I'm sure, the judge, when you get this, you go, oh, what am I going to do? I got to think this through, got to figure this out, yeah, because the judge is going, but I gave you adequate time, adequate notice to do what you needed to do. All right, let's scroll down a little bit more here. That's it, because I'm not reading. The other thing was just a reference to, some other cases there about these sorts of issues. But that's it. So you have this really long letter from the Justice Department saying, hey, yeah, you should have done this, but you didn't. So therefore, since you didn't do it, I shouldn't be responsible for that. This should not be my issue. And like I said, see the color's just all wrong. I don't know what happened. It's like some new tech issue every single time I sit down and get ready to record. But in any case, if that sort of gives you an understanding of how these things are put on in the background, like they show up at trial, but in the meantime, the attorneys, the sides are arguing over whether or not certain exhibits should even be available for them to share during the trial. All right, this brings you up to speed a little bit more. It helps you understand the legal process. And please go ahead and give the video a thumbs up. And don't forget to subscribe. Peace.